Okay. Good morning, everybody. Can everyone hear me? Good. My name is Mary Ennis, and I am the Outreach Coordinator with Seniors NL. I want to welcome you all to this week's Let's Talk session. And today we'll be doing just that. We're going to be talking about relationships. And I'm not referring to the intimate details of anyone's life here, but rather to the legal differences between common law and married relationships. And now I'm just going to share my screen here and bring some slides up. It's so nice to see so many people here this morning. Can everyone see my slides? Good? Okay, great. That's wonderful. I'd like to, first of all, thank United Way, Newfoundland and Labrador, because they sponsor these Let's Talk sessions, and we're very grateful to them for that. Before we move on, I just want to cover a few housekeeping tips here. I'd appreciate it if everyone had kept your mics muted to block any outside noises. I was just telling my colleagues before I opened the session that I have a cat locked in the next room, and hopefully he's not going to be loud enough that everybody in the neighborhood hears him. There's captioning on the bottom of the screen if anyone needs it. And any questions or comments, if you could put them in the chat box, that would be great. And we can go through them once Greg has finished his presentation. This session is being recorded, okay? And one thing I'd like to invite you, if there's any topics that you would like to, see us do a session on here, just let me know by all means, please. And we will give your suggestions every consideration. I'd like to just pause now for a minute to acknowledge the lands on which we live. We respectfully acknowledge the land on which we gather as the ancestral homelands of the Beothuk, whose culture has now been erased forever. We also acknowledge the island of Uktahumguk as the unceded traditional territory of the Beothuk and the Mi'kmaq. And we acknowledge Labrador as the traditional and ancestral homes of the Innu of Nitassinan, the Inuit of Nunatsiavut, and the Inuit of Nunatukovut. We recognize all First Peoples who were here before us, those who live with us now, and the 7 generations to come. As First Peoples have done since time immemorial, we strive to be responsible stewards of the land and to respect the cultures, ceremonies, and traditions of all who call it home. As we open our hearts and minds to the past, we commit ourselves to working in a spirit of truth and reconciliation to make a better future for all. Thank you. Relationships, as we know, come in all kinds of forms, especially today. Common law relationships are more and more accepted. Same-sex relationships, and most people in relationships try their best to give them their all. But no matter how wonderful and together two people can be, there's always, some kind of glitch can be thrown into the mix there. And maybe one of the biggest glitches could be the law itself. So I'm pleased to introduce to you today's speaker. Born and raised in St. John's, Greg Noseworthy holds a Bachelor of Arts from Memorial University of Newfoundland and a Juris Doctorate from the University of New Brunswick. A lawyer by trade, Greg works with the nonprofit Public Legal Information Association of Newfoundland and Labrador, PLIAN, and PLIAN is a really great partner to Seniors NL. Additionally, Greg volunteers with several nonprofit organizations, including as a board member of the Canadian National Network for the Prevention of Elder Abuse. He's a member of the steering committee of Seniors NL's Provincial Network for the Prevention of Elder Abuse, an executive director of Food First Newfoundland Labrador, as well as a director for Nature Newfoundland Labrador. And in his free time, Greg enjoys hiking the coastal trails along the Avalon Peninsula and exploring our beautiful province. And without further ado, I'm going to remove my slides and let Greg put up his. Thank you, Greg.
Thanks so much, Mary. Thank you, Barb. Thank you, Sherry, as well, for having me here today. It's always great to be a part of these presentations with Seniors NL. As you said, Public Legal Information Association takes great pride in having this long-standing, fruitful relationship. So without further ado, my name is Greg Noseworthy, as Mary just introduced myself, with the Public Legal Information Association of Newfoundland and Labrador. Today, we're going to be discussing common law relationships, of course, as Mary said, but within Newfoundland and Labrador. As we'll see, there are differences in other provinces, and we are specifically focusing on our province. So we're only within the bounds of the island and the big land here today. As we get into today's presentation, I'll do a brief overview for those of you who aren't familiar with Public Legal Information Association, PLIAN, as we are also known as. We'll go over some of the laws within Newfoundland and Labrador, and then we'll kind of start to shift to talk about, the kind of the meat of the presentation, common law couples and married couples. What are the differences between the two? And then we'll specifically jump into some of the hotter areas where people tend to have questions, and there could be some misinformation or just have curious questions. So from there, we'll jump into family law and wills and estates. Along the way, I welcome questions. So if anybody does have questions, I have a couple of slides to prompt. So if you'd like to wait to then, that's fine. But of course, if you'd like to interrupt me throughout, whether it's for clarification of something, something you're looking for a little more information, please feel free to, whether if you're comfortable just unmuting yourself and asking a question, or sending the question either directly to me, to everybody in the chat option. Also send it to Mary or Barb or Sherry, and they'll get it to me as well. For those of you who aren't used to using Zoom, on the bottom of your screen there is an option where you can actually click chat, and from there you can ask your question, and you can select whether you want it to be directed to a particular person or to the group as a whole. But let's jump into it. That's a little bit aside. So public legal information, who are we? What are we? What do we do? So we've been around for going on 40 years, which is kind of amazing to say. We're an independent nonprofit organization, and we operate across all of the province with a goal to educate Newfoundlanders and Labradorians about the law while increasing access to justice within our province. We've got two brick and mortar offices, one here in St. John's down on Water Street, and one in Happy Valley Goose Bay off of Grenfell, I believe is what it is. We have a number of different services, which I'll touch on a little bit here, but of course we do things like this as well, as you'll see. So a couple of the key bread and butter services that we do, providing legal information, of course, like we're doing here today. We've got a number of different legal resources, some of which we'll see today as well. We have legal information services specific. So if anybody here today has a follow-up question, maybe you're a bit shy and didn't want to ask it, or you're just lying in bed at night thinking about things, gee, I'd like to ask Greg about that. You can give us a call, you can send us an email, and we can also set you up with a lawyer referral, which I'll touch on in a second. We also do have sexual assault survivor services, newcomer and immigration services, and we're always putting out publications and different information sessions, such as this one. Oh, I went a little bit fast there. Oh, there we go. And Mary, can I just get a quick check? Everybody can hear me fine. Can you hear me as well? Everything's good on your end?
I can hear you fine. Thanks.
Perfect.
Yep.
I should have checked before, but I just want to make sure that, and if anybody does have issue hearing me, please let me know. Perfect. Getting some chat there. So
okay.
See if we're good. Excellent. So our legal information phone line, I said a few minutes ago, some of our bread and butter services. Well, this is certainly the butter of our organization. Our legal information phone line, and we've got a toll-free and local number as noted on the screen there. And this is a service that we offer daily, Monday through Friday, 8:30 to 4 o'clock. where you can give us a call and just ask questions, whether you're looking to learn more about common law relationships, maybe it's something about criminal law, or you just want to learn how to file something with the court, or you want to learn your rights or something like that. You can give us a call. You can chat with myself or one of my colleagues, and we can kind of discuss the situation and see what we can come up with. Again, we do email as well. The info@publiclegalinfo is our general inbox, and the A2J@publiclegalinfo, that's actually my direct email. So if anybody ever wanted to touch base with me specifically, you can email me at A2J@publiclegalinfo.com. And alternatively, of course, you can always just give us a call and just speak to me if I didn't happen to pick up the phone. We try to get back to everybody within about 1 business day. Usually we're a bit quicker than that, so we do our best to stay on top of that. Of course, long weekends such as this past weekend, there'll be that gap in services, so keep that in mind. One thing before we get too deep into the presentation, of course, we're not regulated like a law firm because we're not a law firm, we're a nonprofit. So we can only provide legal information. We can't provide legal advice like a lawyer could. What legal information includes, it's clear-cut law. So the example I have there, you have to be 17 to make a will. We talk about different statutes and laws and regulations, possible options. Can't tell you, of course, the best one because that's legal advice. We can discuss case law or anything else kind of in that umbrella. Of course, that means I can't tell you what your best option is, what you should do, what you should argue, those types of things. And unfortunately, can't give you my opinion if you ask, Greg, what do you think should I do here? So I can certainly direct you, but ultimately it'll be a judgment call on your part there at that point. But where we have that gap in services, we have our lawyer referral service, which is basically just a 30-minute, $40 consult with a lawyer, paid to the lawyer, not us, because again, we're a nonprofit, province-wide, and a great opportunity to get some of that basic legal advice. No obligation to go beyond that, of course, on your end or the lawyer's end. So if you just wanted to kind of narrow down what I've kind of directed you to and get that kind of answer, well, this is a great way to help do that. Any questions there? Anything coming in, Mary? Anybody have any questions about PLIAN or our services?
Not right now, Greg. Yeah, Greg.
Perfect. Thanks so much, Mary. So let's jump into our presentation here a bit. And I always think it's a bit important to kind of bring up some background information, like Mary said at the top of the presentation. Relationships come in all shapes, forms, sizes, and diversity is key, of course, in 2020, 2021 as we go along through the year. So one of the key things here is that all couples, regardless of sex, gender, otherwise, whatever it is, it doesn't matter. We all have the same legal rights and obligations to each other throughout Canada. So that is one distinction that we can make here. There is an exception to this, of course, which is kind of a newer area of law, polyamorous relationships and those other types of poly relationships with multiple partners. They don't necessarily have the same rights and obligations as monogamous couples. So keep that in mind. There is actually some case law here within Newfoundland and Labrador. I don't touch on it in this specific presentation, but we do have not legislation or the case law that specifically deals with this. And it does allow for certain rights for polyamorous and other poly relationships. So keep that in mind as well. The law is always developing, and of course it'll develop in this area as well as more and more cases and facts come out and all these sorts of things. A little bit more background information. So the laws of Newfoundland and Labrador, because again, today we're only dealing with this small geographic area. I say small, but of course our province is quite large. We are based in 2 separate and distinct jurisdictions. Now, what I mean by that, we have a provincial jurisdiction where the laws of the province apply, and then we have a federal jurisdiction where the laws of Canada apply, because we're a confederation of states. A lot of people don't compare us to the United States, but we're kind of similar in ways. Think of each province as its own country. Each province has its own laws, and then there's kind of an overarching theme of laws, such as our criminal law. It's a crime whether you're in Newfoundland or you're in Quebec or the Yukon. It doesn't matter. The crime is the same crime across the whole place. However, anybody's ever been to Quebec, you can't turn right on a red light, for example. That's against the law in Quebec. So there's a good example where there are some distinctions between provinces to province. So each province has its own laws. Keep that in mind. Now let's get a couple examples here, because I always like to give examples, and not just ones that you might say, okay, this is something we can pull out of a textbook, but things that are kind of applicable to people, in real life. So here's a couple of examples of not just laws, but also some programs and policies that we'll see here. So provincially, land and home ownership, that's all within the provincial jurisdiction. So when we're trying to figure out who owns a piece of land or who owns a property, whether it's a matrimonial home or a cabin or whatever, we're looking at the provincial law. We're not looking to what is going on in Nova Scotia. We're looking at the provincial law of Newfoundland and Labrador. We're also looking at personal property, and I always like to use examples. So let's say it's my cell phone here. So when we're talking about personal property, like a cell phone or potentially a bank account, there are some stickier points on bank accounts, of course, whether you're dealing with securities and things like that. But those types of things, cars, TVs, household goods, all that is under provincial jurisdiction. Non-married couple separations, that's also under the province. So that's a bit different. If you see there on the other side, I have divorce, we'll touch on that. But non-married couple separations, we have a specific act for this. It's called the Family Law Act, and it differs from other provinces. And then wills and estates, of course, one of the more common ones that whether we do or don't want to think about it, it certainly is still something we should think about, and it is under the provincial umbrella. Turning federally, of course, federal income tax, I think the one that everybody has to deal with every year. Nobody wants to deal with, of course, I agree. But that's something we have to think about, federal income tax. There's also provincial income tax. We have Canada Pension Plan, and that's a Canada-wide program, unless you're in Quebec, of course. Then we have divorce. And again, divorce legislation is pretty uniform across the whole of the country. And then we have EI, another one that's common. So these are some programs, some laws that are separated under different umbrellas. And of course, what that means is the laws of Newfoundland will apply in a wills and estates situation or property issues. But then we're looking at the laws of Canada when we're talking about divorce, when we're talking about employment insurance. So keep that in mind. Now let's get into some interesting points here. And this is one that usually I think gets a lot of people caught off guard. So I'll just come out and say, common law couples don't exist at provincial law. Now, if you notice, I have an asterisk to that. I have some quotations and I have it italicized because don't exist is a bit of a brash way of saying this. But we'll touch on this distinction. It's a bit of a tricky beast navigating common law couples provincially. Again, we're only talking about the province, right? So what this means is that, if we have a couple and they've been together for 1 day or 1 year or 100 years or more, they don't necessarily lose or gain any specific rights because they are common law. And because of that, I think it's best to think of couples as either married or non-married or unmarried. This is a bit of a different way of thinking of things, but the reality is a lot of our laws in Newfoundland and Labrador don't consider common law couples. We'll delve into some specifics here at a family level and at a wills and estates level, because those are some of the most applicable ones. But this is a bit of a trickier beast, right? There are some very specific situations where you could see a common law relationship having an impact. Again, maybe it's a provincial program or policy. And of course, the law is always changing. So I think as we go through the next few years, we might see some interesting conversations develop around this. There might be some changes, but for the purposes of this presentation, common law couples don't really exist. So common law at a federal level, though, again, we're talking about Canada-wide, completely different. Again, it depends from program to program, policy to policy. There's this joke when we went through law school. Anytime we didn't know the answer to a question, we always said, well, it depends. But I think that's somewhat true of anything anyways. No matter what we're dealing with, it kind of depends on the specific situation, whether that's, again, a polyamorous couple or maybe it's just two people. Maybe it's provincial law or federal law. But again, for the purposes of our presentation today, common law doesn't exist at a provincial level. It does at a federal level. They're two different areas of law, so let's keep that in mind. So let's jump into some areas of this, because I'm sure everybody's a bit curious about where we can see some examples of this. If anybody's curious, that is beautiful Southport, Newfoundland and Labrador on the southwest arm. That's actually a shot towards the harbor there, coming from my uncle's property. It's very beautiful area. If anybody gets a chance to go, highly recommend it. Jump into land ownership, folks. We're looking at some land. We're looking at some properties here. You can see everybody's got their wharves. My uncle's wharf is on the bottom right, if you're curious. So these are things that people own, right? And it's land ownership, sometimes water ownership too. Bit of a trickier beast. But when we're talking about this provincial law, couples don't actually gain rights to property based on relationship status, unless you specifically opt into it, right? So if you're married, we're talking about a different ballpark here, right? But we're saying at a common law level, you don't just get it. You don't just automatically get it because you're in a relationship with somebody. Our Family Law Act, again, our provincial legislation states that only married couples specifically, right? That's what they define a spouse as. So spouses are defined as married couples under the family law, regardless of any qualifiers to that. They have an equal 50-50 right to matrimonial property. So let's say that one of those houses in the background is the matrimonial property, right? It's just the one home where the family lives. If you get married, both couples are going to have an equal share to that house. Doesn't matter if it's only one person's name or not. Because you're married, Family Law Act, it says that you own it together. It's an automatic right. So that's when you're married. The second you get married, just like that, you own half the house, right? Now, if we're talking about common law, though, again, it doesn't matter if we've been together for 50 years, right? A lot of couples are together for 50 years without getting married. You don't have that because, again, the Family Law Act doesn't state unmarried couples. It says spouses are defined as married couples. So it's a bit different. However, some couples choose to create what we call a domestic contract. And that actually gives rights. So if we have common law couples, like say my spouse and I, we're not married, so we don't have rights based on a relationship. Maybe we decide to do a domestic contract together. You might hear people throw around different languages like cohabitation agreement, those types of things. Prenup is one that everybody tends to be aware of, but domestic contract is the language. That might give rights to the house. So there's those types of things. Bit of a trickier beast. You can already see, though, where there's some kind of schism there between people thinking they might own something or have a right to something because of the relationship, even if you have kids together, but you're not married. So right on the face of it, you might not actually have any right to that property. Let's jump into personal property here. So I have a couple of examples there. Few of them I think you might find in the same room, but certainly the last one I don't think you would with the toolkit. But personal property, it's really almost anything that can be owned by a person, of course, as long as it's not land. And it can be owned by one person or more, and that's what we call joint ownership. You can have 2, 3, 4, 400 people jointly own something, and that's the same thing with land as well. Common examples of this, of course, as I have on the screen, money being one, household items and cars. So those are a very common one. 2 people buy a car together. Bank accounts also can be set up to be owned jointly. And then there's other things that are kind of bought together during a relationship, whether it's, a TV or, a table or something from the kitchen, those types of things. And the one thing I have there kind of curiously is pets. I always like to bring this one up because it is a bit of an interesting area, and we're going to touch on that in a second. We do have a question coming in. So the question is, you say once you marry, you own half the house. If there is a prenup agreement, does that still apply? Yeah, and that's the caveat there. Of course, we're going to touch on that a bit more in the presentation, but I think it's good to bring it up now. Whenever you have any kind of domestic contract, prenup, or any agreement, those types of things, that impacts those types of relationships and what you might or might not own. Really, marriage in itself is just a contract. It's 2 people agreeing to give rights and obligations to each other, and we think of it as kind of that romantic thing. But at law, marriage is just a contract, right? I'm agreeing to give you half of everything I own. You're agreeing to give me half of everything you own. We're going to have these rights and obligations to each other. If anything happens to ourselves, You'll get in on the federal programs. I'll get in on your federal programs, pensions, so on and so forth. That's a great question. And, some of the caveats here too, I think another important one I should make a point to bring up as well is that, when we're talking about land as well, again, land is a bit of a trickier one to handle, but when I'm saying these things, so there we go. When I'm saying these things that, just because you're in a relationship and you're together for 50 years, I said on the face of it, you don't own anything. There are certain specific situations where you could apply to court to get potentially something out of a house, but I always say it's kind of like going up a hill like this. You got to hit all these loopholes. You got to jump through these hoops. You got to jump through hoops. You got to hit certain requirements, and if you don't do that, you won't establish that ownership or that right. So it's always possible that something could happen, but it's a harder standard to meet. I see we got a couple more questions coming in. We'll just get a few of these out of the way here now, because these are great. Is any property acquired together during a relationship 50-50, even if not married? So the example, if myself, my partner who are not married, build a house together tomorrow or buy furniture together, is that stuff 50-50? So again, kind of getting back to what I just said a second ago, it kind of depends. And I know it's a really bad answer and it's not a satisfactory answer. But let's take the example of, let's say I own a house, just myself, but then my partner comes in and, puts in new windows one year, puts on a new roof for me one year, and it's always taking care of the lawn and, shoveling the driveway and doing all these things. Okay, maybe they don't have 50-50, but they might have an interest in part of the house. So again, you see where it can be kind of a bit of a touch and go type thing. That's certainly beyond this kind of presentation. Lawyers, when they're going through school, they have to spend 3-6 months just to figure out this area of law. That's what we call trust law. The law has ways to work out things, but nothing's guaranteed when we're talking about these common law situations. So keep that in mind. If you buy something from the same pot of money that you keep contributing to your joint bank account and you jointly buy a TV together, well, that's pretty clearly 50-50. That could be 50-50 with your friend too. It doesn't mean, just because you're in a relationship or not, you can't have that 50-50 ownership. I've certainly bought things with friends and we own things 50-50. So there's that as well. Keep that in mind. That's another thing. One other question, we'll keep moving here. How often would the prenup be in effect for? Would the agreement need to be updated periodically? The reality is, and again, we're dealing with questions here that are very fact specific. So it kind of depends on how it's drafted. Some agreements might say that this will last up until a certain date or time period, or it won't apply until something happens. So for those types of things, there's not much I can really add to more than just say, it's a contract and you can pretty much freeball almost anything with, of course, certain exceptions on that. But you can get really creative with whether it's a prenup, a domestic contract, or otherwise. Great questions, though, folks. Great questions. And we'll have more periods throughout the presentation for questions as well. But we're going to jump into talking about pets. We're talking about personal property here, joint ownership. And I think this is a good segue to get to this one. A lot of people are always wondering. I get this question a lot. I don't know why. I guess just more and more people are having pets as children instead of children as children. But couples buy pets together. Or sometimes one person buys the pet and maybe gives it as a gift. This is a very hot area of law right now. And unfortunately, as unsatisfying as this answer is going to be, this next point I'm going to make, but pets are considered property. They're not like you and I, right? They don't have those rights like you and I. They are owned. They're kind of like livestock, like a chicken or a cow, right? Or this puppy here. We own pets in the eyes of the law. And this is pretty settled law. And I have an example there. I don't usually have case examples, but we have a nice one here. And I was taught it at the bar course, so I always think it's important to bring up. In some cases, though, you might see where one party, if they're splitting up, they might decide to buy out the value of the pet from the other one, whether that's the $500 it cost to maybe bring the pet here from Ontario or vet bills or whatever. But our case, Baker and Hermina, Baker v. Hermina, you see there, of 2018 Newfoundland and Labrador Court of Appeal. So the highest court within our province, there is always the Supreme Court of Canada, which is for the whole of the country. But our highest court in this province heard this particular case. I always make the joke that, I think they could have changed the name to Barker and Hermina. So I think they missed an opportunity there. But Baker and Hermina. So it's most recently reported pet ownership case, Newfoundland Labrador. Not to say that there's not more recent pet cases, but it's the most recently reported one, meaning it was wrote down. And they basically said that the traditional approach of who actually bought the pet will prevail. So who bought the dog in that particular case, they said that is going to be the owner 100%. Of course, we can't split a pet 50-50. That's not something we do, right? This isn't the Hammurabi Code or anything like that. So that's a bit of a different beast. When we're looking at that, it comes down to who bought the dog. Now, of course, if you buy the dog and gift the dog to your partner, okay, that's different. You've given away your property. So different consideration. That wasn't talked about in this case here, but it's interesting to note. So puppies are property. Remember that one. I know it's a bit of an odd one. I always kind of feel funny saying it, but there we go. Any other additional questions as we go through we're going to go into some specifics here now, but that's the background noise that we have to deal with, whether it's land or personal property or pets.
Greg, it's Mary. I was just wondering have you addressed all the questions that came in early?
I did, I think. Let me just
The ones
get my channel.
One thing I just want to let everybody know that there were a couple of text questions, and I am going to send, I'm going to send everyone after this meeting is over, or by tomorrow anyway. I'll be sending everyone a copy of Greg's slides, a link to the recording for today's session, and I'm also going to send you a contact person and contact information for a woman with Revenue Canada who can answer any tax questions that you've put forward. Or I could get the answers for you and send them out. But either way, we will try to take care of everybody's questions. Okay, great.
Perfect. Thanks so much, Mary. Yeah, and I think I did just check there. Pretty sure we're all good on the questions. Of course, if something comes in, I think the last one I kind of addressed. So if that's not really clear, just please let me know, and I'll certainly specifically touch on it. This is great discussion, though, folks. Please keep them coming. I thoroughly enjoy answering questions, and I always welcome because I think it's good back and forth. And if you're not getting something, then somebody else in the audience might not be getting it too. And I think that's important. And if you're not, please let me know so I can jump into it a little bit more, make sure everybody understands what we're talking about here. But we'll keep moving here. So we're gonna talk about a little bit about heartbreak here now. We're gonna talk about separation. So separation is a bit of an interesting question, right? So separation is a process there for non-married and married couples. So one of the things I like to touch on is the difference between the two is kind of the end result. Of course, if we're common law, or as we'll now call them, unmarried couples, if we're talking about unmarried couples, they're not going to get divorced. There's no divorce at the end that will finish it off. Of course, if you are married, divorce is the ultimate end game to separate both persons, and then that will end that relationship. If you're separating as a non-married couple, then your separation is going to go through our provincial law. So again, that's when we're talking about our unmarried couples, we're talking about a provincial law, and that's our Family Law Act. And again, as we were touching on briefly, that specifically sets out what they define as a spouse and what they don't define as spouses, or rather the other way. If you are separating as a married couple, though, you're going to be looking at two pieces of legislation. You're going to be looking at the Family Law Act for the provisions that do apply there. And then you're also going to be looking at the Divorce Act, that Canada-wide act that applies whether you're in Newfoundland, Labrador, or you're in Alberta or Ontario or wherever. The Divorce Act was actually just recently updated, and it's going to come into effect later this year. So that's an interesting thing to note. It was supposed to come into effect last year, but COVID kind of messed up everything. So keep that in mind. And our Family Law Act is, as far as I know, due for an update, but that hasn't happened yet. It should be soon. We've got a couple of questions coming here, so let's get to some of these. So if I own a business, employ my friend, he lives in my house, contributes to the household bills, had his own house, sold it, banked the money from the sale. If I sell my house, can he claim a portion of the sale? So business part doesn't seem to really apply there so much in this, in the employment part. It's really interesting to see the living in the house part contributes to the household bills. Okay, so what is contributing to the household bills? Ultimately, I can't say 100%, but if he's paying half the mortgage and putting in the windows and putting all these things in, he's been doing this for 10 years. That's what we would call building a case. Of course, it's not guaranteed, like anything we've said here today. Certain things can, on the face of it, appear as though there could be something. But we also look to the intention of the parties, what they intended to do. If you're not setting up a relationship, those types of things for a property, it's a bit of a trickier beast for them more than anything. So, you really got to look at all of the facts, and without all of the facts, I wouldn't be able to say, and of course I can't, because that would be delving into the legal advice side of it. That said, I'm always happy to chat more about that. And that seems like a very specific situation where our lawyer referral service might be a useful thing for you to avail of. So certainly feel free to reach out. Does a will cover common law relationships? I'm going to leave that one because we're going to come back to that. So we will get to that shortly. So stay tuned for the will section. So that's our separation section there, folks. So keep that in mind. We have two pieces of legislation that may or may not apply. So keep that in mind. Now, what are we going to talk about when we're talking about separation? There's a number of things. Children are always paramount, of course. We've got to make sure that the kids are okay. And the rights and obligations that we're going to have with birth parents aren't going to be affected by whether or not a couple is or isn't married. That's because parents have obligations to their children, regardless of their parents' relationship. So keep that in mind, of course. Even if mom or dad has another partner, right, that those obligations still remain. Those rights and obligations still remain. There are things that might have to be considered, though, of course, with separation, and that could be a parenting plan, whether it's going to be a 50-50 parenting where I'm going to see my kids and parent them for 1 week, next week you will do it, that kind of thing. Or a third parent, even, as we dealt with in a recent case with polyamorous relationships. Possible child support, another big consideration there when we're dealing with separation considerations. Spousal considerations, splitting up property, again, we're dealing with here. One of the things is the law is flexible, and sometimes people understand that, I don't have to give you something based on the law as it's what's wrote in stone. However, I choose to do that because, one, maybe I just want to, or maybe because I don't want to have to go through an expensive court process only to find out that I was right all along, or maybe that I was wrong all along and I'm trying to protect myself. So there's those types of things. Sometimes spouses, what they'll do when they're separating, whether common law, unmarried again, or married, they might kind of do that stuff themselves because ultimately, they know their situation better than the judge would, and they decide they're going to handle it. It's also a great way to save on lawyer fees and court time and stress and all that kind of stuff. Pension divisions, very complex area. There's a lot going on there. Not my ballpark, so I wouldn't want to touch too much on that, but that's another consideration that comes up a lot. Spousal support, although spousal support, unlike child support, is not it's not guaranteed, which is one of those kind of common misconceptions. Spousal support really exists to make sure that the spouse who's receiving it can become financially independent. So, of course, if you have a spouse who is, has a proper career and has no debts and those types of things, okay, spousal support is certainly less likely to be applicable there because they can survive on their own. So, kind of keep that part in mind as well. I do have a question, I believe. These are great questions. Is there going to be any change to the existing law given the trend in common law relationships? Ultimately, we just finally got our government. So anybody who's curious about any changes to the law, I certainly recommend touching base with your MHA. They're the ones that change the law. Of course, when we get to case law, that's up to the judges. That's what we call the common law, judge-made law. We don't know when that's going to change until the decision comes out, unfortunately. But if you're curious about whether or not House of Assembly is considering any changes to the Wills Act or Family Law Act or anything like that, touch base with your MHA. That's why we elected them, and hopefully they'll get back to you about that. Some further separation considerations. So again, just as I said a second ago, and I really like to reiterate this here, just because I think it's an important thing. A lot of people going through court processes, they often find, halfway through it, a year or two in, that things aren't what they thought it was going to be. It's very expensive. It might be hard to make ends meet now because of all the costs and things, and COVID came up and all these things. So I think it's important for everybody to know that couples can agree on what's going to happen with their items, that matters in their separation, whether that's children or property, vision, those types of things. So keep that in mind. It's pretty clear what the child support requirements are. We have mandated guidelines on those. But if you want to pay more, you certainly can. Or if the parents decide that, that's too much, I know that you can't afford that, they'll do less. And as long as nobody kicks up a stink of court, that's fine. But of course, if it's not possible, ultimately, I think we have to go to the courts. They're the arbitrators. They're there to do this. And a lot of people don't want to go to court, but unfortunately, that is how we resolve a lot of our disputes. There are mediation services as part of courts processes, and they're mandatory, in fact. So you have to go through those before you trial. Trial is so far down the road. I wouldn't be thinking about that. For divorce, your application's got to go through the Supreme Court Family Division. And then for your non-married separations, your application could go through one of the two, Supreme Court or Provincial Court. Kind of depends on what it is and where you are. Let's get into the wills and estates. So I promised I was going to touch on the wills and estates and common law and married couples. So let's touch on that. So again, remember, non-married couples don't have any inherent rights at provincial level in relation to their partner. And this is an area which is much more certain than other areas as to that provincial requirement. When we're talking about common law couples here, the unmarried couples in wills and estates, there's no inherent right to anything. Again, it doesn't matter if you've been together for 500 years. There's no inherent right. It doesn't mean you can't get anything. It just means that you don't inherit it automatically. For married couples, whether you have a will or not, you're going to have some protection there. We have what's called the Intestate Succession Act. Intestate means dying without a will. And that ensures that if their spouse dies, their married spouse dies without a will, that their partner, their surviving partner, will receive at least 33% of their share of the partner's estate. That's a minimum. So keep that in mind. This one kind of it changes depending on if there's kids involved and how many there are and those kinds of things. So that's why I say a minimum of 33%. It is possible that could dip below 33% if the person who died set up everything to basically pool to another person. But even that is so rare. You don't really see it happen that often. That's what we're talking about, pensions and those types of things. This particular act doesn't give any rights to an estate for a non-married person. So keep that in mind. If you're in a common law and unmarried and non-married relationship, as we like to call them now for today's presentation, you don't have any rights there right on the face of it. So keep that in mind. But if you are married, we do have some other considerations, right? So we're going to go back a bit here. We were chatting just a few minutes ago. So we're talking about wills and estates. We're going to talk about the family home, the matrimonial home. Remember I said earlier today that when we're defining spouse, the Family Law Act defines spouse as two people who are married. Well, this is where this is particularly interesting, right? So spouses in law and this law don't include unmarried couples. So your matrimonial property, your family home, as it's sometimes called, this is the property where married couples live together. And the Family Law Act, it creates this right of joint tenancy, as I already mentioned. So keep this in mind again. What this means is if a person is not married, if two people aren't married rather, and they don't have a will, right? Okay, they're not doing great. You mightn't have any inherent rights to the property or to the estate. But if you are married and you don't have a will, just because you don't have a will doesn't mean you're not going to get anything with regard to the house, right? We got that minimum 33-ish%, as we said. But this means, of course, that if you have that married relationship and you have one person owning the property, either person, doesn't matter. Once they're married, you get that 50-50, just like that, as I said. This creates that right of survivorship. And when we're saying that right of survivorship, that means that whoever survives the other person automatically inherits the property, regardless of whether there's a will, right, or not. So keep that in mind. So that happens automatically. The house will go right to the person who survived. That's another way our legislation protects married couples. Again, with regard to unmarried couples, this might change in the future. It isn't yet. I'm not aware of any changes coming. The reality is with COVID, I don't imagine there'll be a ton of changes coming very soon, but it's something that might change. Question coming in here. Didn't understand comment on not and a will. Okay, yeah. So I'll just go through this section here. So the thing is that if you are married, right? If you're married and you don't have a will, you have this right to a matrimonial property under the Family Law Act, right? So we have that 50-50 thing there. If you're married and you don't have a home, let's just say you're renting an apartment, right? And you're married, there's no kids, and you don't have a will, then you get 100% of everything anyways, right? That's automatic. There are some caveats there on that joint tenancy thing. Again, remember that. And I think a good example could be if I own something with my friend, like maybe we have a bank account together where we buy things for our hobbies together. Maybe we always had it set up so that the other of us will get that bank account. That's a caveat there, of course. But when we're talking about married couples and unmarried couples, there's that difference, right? With the Intestate Succession Act, the Dying Without a Will Act, the married person automatically gets everything, with the caveat of kids, of course. But if you're not married, you don't have a will, you don't have any inherent rights. That's the big tricky thing. If you're not married, you don't have a will, you don't have the inherent right to anything of your common law partner's estate. Doesn't matter if you've been together for 50 years. I hope that was a bit more clear there. If it's not, please let me know again, folks. We're going to keep going with this section, which delves into it a bit more. So hopefully this will kind of clear up some of this. How non-married couples, though, protect spouses, again, because if we're not married and we don't have a will, it's not looking great, right? But there are other ways to do it. You can have both partners, or both parties, rather, in a relationship on the house. So that means that both people own the house together anyways. That's going to create that definite right to survivorship, right? That automatic transfer of the property. You could always, of course, just simply sign a will that gives your share of the home or your estate or property or whatever it is to the other person. And I always make a note that you can be very flexible there. Maybe you have some other people in your life that you have to think about, because reality is sometimes people choose not to get married for a reason. So keep that in mind too. You can also add your partner as a beneficiary under different programs, whether it's a pension program, RRSPs to give them contributions there, life insurances. You can do all these things. And this takes place outside of the will. So that's another avenue to help protect your partner. Of course, again, maybe if you don't want to, you don't do this, but those are ways to do it without having to sign a will or get married or whatever. Right? There's tons of options here. And then there's always one we were touching on, creating a domestic contract. You can do this to create certain rights and obligations to each other. Lots of ways to do it. And let's touch on this, because I promised we were going to touch on domestic contracts. It's sometimes referred to as cohab agreement, as I mentioned earlier. And these create various legal rights and obligations. Again, as I mentioned, sometimes called a prenup. People who are intending to marry can sign a marriage contract, and this can continue on, after the marriage part. And actually influence what happens if you separate and divorce, those types of things. But you might exclude rights too, is one thing I always like to make a note of with these domestic contracts. You might actually say that, we're not going to have the Family Law Act apply, so I'm specifically not going to give you any of my property under the Family Law Act. And you say, yeah, that's fine. I know you want the family home to stay in the family or something. It can be specific to personal property development if there are family heirlooms. So we keep this in mind. You can separate your rights and obligations. You can give rights and obligations. You can exclude rights and obligations. Whether you decide to get married or stay, you have options to do it. The thing I always say, of course, is The second you die, you lose that ability to do that. So if you don't do it while you can, well, unfortunately, you know, dead men can't speak, the old expression, that kind of thing. Keep that in mind. And the courts are going to have to go off the fact that, you know, Greg didn't create a will. Greg didn't marry. Greg didn't put his partner on the property. Doesn't look great that Greg really wanted you to have that house, as although you're telling the court that he had 3 opportunities that he was aware of and he chose not to do that. Looks a little bit odd to the court, right? So I think that's an important point to keep in mind. One thing I always like to bring up as well is the impact of marriage and divorce on wills. If 2 people get married, if they have a will, or if one of them has a will, that will automatically is revoked unless you specifically put a clause in it that says, no, I intend to marry such and such. So Barb, I'm going to pick you out of the crowd here today, Barb. So Barb, we're going to be getting married. I have a will. I know I like my will. And when we get married, Barb, I don't want it to be, you know, revoked. I don't want to go ahead and pay another lawyer. So I put a clause in it that says, you know, I'm intending to marry Barb Benson, and my will is going to apply after the fact. So that'll prevent my will from being revoked automatically. Kicker there, of course, is if me and Barb decide to get divorced. Unfortunately for one of us, I'm sure one of us will think that way, it doesn't actually impact the will. So if you get divorced, the will is still in effect, and you'd have to go out of your way to revoke the will or sign the will. So keep that in mind. And separation has no impact on wills at all. So keep that in mind too. So we're getting towards the end here. So I just want to bring out a couple of common misconceptions, and then we'll get to some of the questions. Again, this was a bit of a quicker presentation today, so it's kind of hard glossing over some of the points and not getting super detailed. So I always welcome anybody, if you have questions after the fact, please reach out to me. That's more than okay on my part. You know, this is what we do. This is what we get paid to do. I really enjoy doing it. If I didn't enjoy doing it, I'd still have to do it. So please feel free to reach out to me anyways. But some common misconceptions, you know, again, couples living together become common law after 6 months of living together. That's not a thing. Again, as we saw, common law doesn't really exist like people think it does. I'm not sure why this one has come up or where it's come from. You know, after 6 months of being together, you're common law. That's not a thing in this province. I'm not aware that it's a thing in any province either, to be honest with you. But just because you're together for 6 months, it doesn't create any obligation or rights to each other. Common law couples have guaranteed rights to a home based on the relationship. Again, not true. If you're married, okay, fine. We have the Family Law Act. That creates something different there. But we have our caveats, like we were saying here. We have our domestic contract. Maybe that changes it. So again, even if you're not married or you are married, you don't have, or sorry, if you're not married, you don't have that guaranteed rights to the home. So keep that in mind. Common law couples have guaranteed rights to the estate of their deceased spouse. Again, as we saw, the Intestate Succession Act does not provide that. Spouse is a married person under our Family Law Act, under our Intestate Succession Act. It's married persons that have that right to estates. So if you're common law for 100,000 years, you don't, on the face of it, have that guaranteed right to a person's estate. So keep that in mind. One thing I always like to make note, just a couple more slides there, Mary, and we're done.
Okay.
All good? Yeah.
We have 5 minutes, Greg. Sorry.
Perfect. Thanks. So we've got a family form builder. This is an interactive to use program, completely free. Everything we do, of course, is free. Generates court forms if you're going through court and you're separating or divorcing. So please keep that in mind. The link is there as well, and I can always forward it to you. We've got a number of other resources as well, publications that deal with the topics we're talking about here today. So please let me know if there's anything you want, and I'll get that to you, no problem. We're always expanding our services and our reach. So if there's anything anybody's aware of, you'd like us to talk at something, please let us know. Anybody here is part of a different group or anything like that, please feel free to reach out. More than happy to do up a presentation for you. No problem at all. That's it from me. I do have a couple of quick questions. We'll just, I'll leave that on the screen there for a second. If anybody wants to write down my contact information. A couple of quick questions here. Some we can't answer. There's one on tax purposes. You know, I really don't know enough about taxes to guide you either way. Talk to an accountant, call Service Canada. They're the ones that you want to chat with the CRA. Another one here, if your partner passes away, would the survivor be entitled to a portion of the pension, POAS? again, these programs are always changing. Not something I'm comfortable being able to say much on. I'd have to look into it, to be honest. And Mary said, of course, she'll get the information to you guys. Explain what rights does a common law partner have in separation or death? Well, as we saw, it might not be much of anything. So keep that in mind. It's a tricky beast to navigate. What are the legal rights of my partner, common law partner, if I purchase a house by myself and he/she comes to live there? Again, it's one of those things. They mightn't have any right at all, but depending on how everything is going, maybe they can make an application in court to get something. Bit of a trickier question. You always need the full picture on these ones. And then the last question, what happens if neither party wishes to claim common law partnership and wants to live as roommates? How can they go about this? Well, again, you don't automatically become a common law, like we said. You're either married or you're not. And if you just want to live as roommates and be partners that way or whatever, you can do that. Consider, of course, maybe you want to get the domestic contract, prenup, those types of things. That might be useful for you in those situations. That's it for me, folks. I know we're coming right up on time, Mary, so I'm going to pass it to you for any last words there.
No last questions from anybody? I'm going to take you for screen down now, Greg.
Perfect.
Anyway, Greg, thanks so much. That was lovely. And I really hope that everyone got, the answers to most of the questions that you wanted to ask anyway. And as Greg says, you can always get in touch with him, or you can certainly get in touch with me. And if you have any other questions, and we will get them going for you. So next session is let's talk about drive safely, drive wisely, and that is going to be next Tuesday, April 13th. And also we have one coming up later on this month, advanced care planning, talking with loved ones. And that's having a conversation with loved ones so that they will understand what you need and what you want in terms of your health care as you get older. So thanks again, everyone, and thanks again to United Way for their support of our information session. And I really appreciate you all being here today. And Greg, certainly appreciate your taking the time.
Pleasure. Thanks so much for having me, Mary. It's always great to do these sorts of things.
Oh, there'll be more. Bye, everybody. I'm going to close off now, and we'll be sending information to you tomorrow. Bye.
See ya.